I'm Mike Kelber. I am the Legal One coordinator of online course development, and I welcome you to this next section, section 4 of Module 3, Staff Rights and Responsibilities. This is our section on collective bargaining rights. Start from the fact that public employees have the right to bargain terms and conditions of employment according to the New Jersey Employee Relations Act, sometimes called the PERC law, which has been in effect since 1968. Know that collective bargaining agreements are legally enforceable contracts, and from an employee's perspective, and also from a supervisor's perspective, keep in mind that all employees have something that are referred to as Weingarten rights. It comes from the U.S. Supreme Court decision in NLRB versus J. Weingarten, Inc. And essentially, when an employee is being called into a meeting where there's an investigatory interview or discussion that could result in potential disciplinary action against that employee, they have the right to union representation during that meeting. That could be an evaluation conference, that could be any other meeting they're called into, and that's important to know from your perspective as an employee, in terms of that being your right, that your union can represent you if you are a unionized employee. And if you are a supervisor and someone is coming into your office in terms of a discussion and interview, and it could result in disciplinary action against that person does have the right to bring representation with them. So the Weingarten rights are important to remember. We'll talk about them later within this module as well. So let's talk about collective bargaining. 2 or more individuals are required to form a collective bargaining agreement. 1 person does not a unit make, but if you have 2, you can have a union and you can have a collective bargaining unit. The board, once you establish that and you have a majority representative representing your unit, the board may negotiate over terms and conditions of employment only with the majority representative. It cannot go to individual persons and create separate deals on the side in terms of whatever the terms and conditions of employment may be. Can't be more punitive, can't be more generous, has to all go through the majority representative. And those are matters that directly affect working conditions such as work time, workload, time of day, all kinds of things along that line. We'll talk a little bit about that more going forward. Boards of education, like any other public employer, have something known as managerial prerogatives. There are rights which employers have to effectively manage the schools, includes rights and responsibilities controlled by statute and regulation. That sounds really good, but now what does that really mean? For something to be negotiable, this is the 3-part test, the I-195, Local 195 test, because that's a New Jersey Supreme Court case that set this forward, that established whether something's negotiable or not. First, it has to intimately and directly affect work and welfare of the employees. Second, it cannot be preempted by statute or regulation. So if there's a statute that speaks to the issue, the statute controls and provides the floor. If there's a regulation at issue, the regulation controls. And the issue must not significantly interfere with the exercise of managerial prerogatives pertaining to determination of policy. That's some nice language, but let's see what that means in practice. What are some of the mandatorily negotiable topics? Salary, benefits, assignment and retention in extracurricular activities came out of the scope of negotiations amendments to the PERC law from 1990. So all aspects of that assignment and retention in extracurricular activities are negotiable. So look to your contract. And grievance procedures are mandatorily negotiable. So you'll notice that they're part of every collective bargaining agreement that you've ever seen. They're not in policy because that would be done by the board. It wouldn't be negotiated. So grievance procedures are all negotiable. What's non-negotiable? Minimum number of sick days is one of my favorite examples. 18A 30-2 says every steadily employed employee gets 10 sick days a year. You could not negotiate 5 to only get 5 or 7 or 8 for full-time employees. The minimum number is 10, preempted, can't do anything less than that. Family Medical Leave Act, Family Leave Act, both on the state and federal level pieces, that's part of legislation, that's non-negotiable. Extended sick leave under 18A 30-6 says the board has discretion to extend leave beyond that which you've accumulated on a case-by-case basis. We'll see a case coming up later on where there was a piece in the contract about that found to be non-negotiable because the statute precluded. I'm old enough when I was teaching that I was making less than $18,500 a year when the 18.5 minimum salary came into play in the mid 80s. And I got a raise because the minimum teacher salary was moved up to, under Governor Kane's administration, to 18.5. Kind of hard to believe that that was a big deal back in the day, but it caused a ripple effect through all other salary schedules throughout this, and you see where we are now today. We know about the Chapter 78 health insurance contributions that were that statutorily created. Now they became the floor for negotiations, and that's negotiable, but you cannot go below the 1.5% contribution to salary that the previous health insurance contribution statute maintained. That did not go away. So no matter how aggressively a union may bargain, the employee contribution to health care will never go below 1.5% of salary. State disability leaves, non-negotiable, and the evaluation rubrics we saw earlier talked about them. They are non-negotiable items as well. We also get items that I would refer to as split topics, where there's a prerogative to make the decision, but you have to negotiate over the impact of the decision. A good example that's pretty concrete, except for this year when winter weather wasn't so bad, school calendar. The board has a managerial prerogative to set the school calendar. When does school start? When does school end? What days are you going to have off? They can consult with the union in the creation of the calendar, but ultimately it is the board's determination unilaterally to decide what the school calendar would be. Now, if you have a lot of snow days during the year and you have to make them up, that is negotiable because the board can change, decide when those snow days are going to be, but they need to negotiate with the union over the impact of that. So if they're going to take days off of spring break, for example, perhaps there are employees who had already scheduled vacations, or they made deposits on trips, or they did different things. You need to negotiate how we handle the impact of that. Maybe there would be the ability to take personal days or something along those lines, but negotiability, that's important. In staff evaluation, it's important to distinguish the difference between the criteria and standards for evaluation, like the rubrics for evaluation. That's a managerial prerogative, not negotiable. But the procedures for evaluation, when you would meet, how you would meet, what the conference looks like, the timing of all of that, except where statute and code have preempted it, those are negotiable as well. For reduction in force, if positions are eliminated, that's a managerial prerogative to eliminate positions, but the impact of those decisions, which may create increased workload, those are negotiable items as well. So you've got this split topic of decisions. And here's a good example of one that came down just this past summer in July of 2018. This was in Belleville. The board, in terms of implementing improved security measures in the school, had decided they were going to install cameras and require staff to wear radio frequency ID cards. And that was a managerial prerogative to ensure the safety of students and staff. However, the impact of that decision, what happens if you lost a card? Where would the cameras be? What would be availability to the tapes? Who would get to see them? How that would all work? All of the impact that those items would have on staff, that was something that was mandatorily negotiable, and the board erred when it did not negotiate that. The board in this case also at one point actually filed tenure charges against the union president, and it committed a ULP, or unfair labor practice, because it filed charges against the union president for that president's action in retaliation for the president's protected union activity. Advocating against the board policy was the key. So the board was found to have committed an unfair labor practice. One of the interesting quirks of this particular case is when PERC, the Public Employment Relations Commission, issues a decision, there is an ability to enforce that order of the agency in the Law Division of Superior Court. Generally, anyone who's aggrieved in those circumstances can bring that action in Law Division of Superior Court to enforce the order. But in a quirk of the PERC law, only the Public Employment Relations Commission can bring that order, can bring that enforcement action in Law Division. In this case, the Belleville Education Association sought to bring that, and it was found that they did not have the authority to do so. They could ask the PERC do that, but they did not have the authority to bring it there themselves. West Orange Board of Education versus West Orange Education Association. We have seen a lot of increased tension between unions and boards of education. And we'll talk about the impact of the Janus decision later on, but I think that's part of the reason we're seeing so many labor relations type cases in this past year, a great increase in that. But here's a situation where a contract had a provision that provided for supplementary sick leave for staff, not a sick leave bank, but supplementary sick leave for staff when they used up their accumulated sick time. The negotiations were about to occur. There was an expired agreement. That's the expired K that you see there. And so the contract expired on June 30th, and the board was moving forward. They went to PERC for something called a scope of negotiations position, saying, we don't believe this is negotiable. Please take it out of the contract. We don't want it in the successor agreement. And in this particular case, the board was successful in removing the contract provision from the agreement because the statute 18A 30-6 preempted the negotiability on that topic. So here we have a situation where the contract did include something that was clearly non-negotiable, that for whatever reason it had been agreed upon by the prior agreement, the union and the board. The board went to PERC to have this removed, and it had it removed because it violated the statutory provision giving the board discretion in awarding those extra paid sick days under 18A 30-6. West Morris Regional Board of Ed, another situation, a scope of negotiations petition to PERC, another situation where the contract had expired and they were into negotiations, another situation where the board said, we're going to PERC to have this provision taken out of the agreement because it is non-negotiable. It shouldn't have been in there in the first place. Obviously, the union didn't agree with that, or they wouldn't have had to have gone to PERC. So in this particular case, it was a question of the start and end date of the school calendar. Now, the provision in the contract said, staff members under this contract shall be employed from September 1 through June 30. That sets the school calendar. Again, a non-negotiable provision. And that was removed from the future contract through a scope of negotiation petition with PERC, affirmed by the appellate division that that was non-negotiable. To distinguish this case from the Piscataway case in 1998, which dealt with, as we talked about earlier, the makeup of snow days, that the impact on the makeup of snow days would be negotiable. But the initial setting of the calendar, as occurred here, was a non-negotiable managerial prerogative. And the appellate division upheld PERC's decision to remove that from the contract in the subsequent contract. This is one to sit up and take notice about because it's good for two reasons. One, it's a very interesting decision. It could have an impact on a lot of people, potential retirees, and payment for unused sick time. Also because the New Jersey Supreme Court granted certification in January of this year, and we'll be hearing this case, so they will be coming down with an issue on a decision on this. The issue is this. A lot of times in a series of collective bargaining agreements, the amount of payment for unused sick time gets decreased from one contract to the next. In this particular case, we had 4 employees in Cliffside Park who were about to retire, and their 2012 contract had a $25,000 cap on unused sick time and a certain number of days. The 2015 agreement reduced that maximum to $15,000 and decreased the maximum number of days that could be considered. The employee said, wait a minute, you're taking stuff away from me. You're taking reimbursement away from me that I've earned. And the question is unpaid sick leave earned compensation? There was a Morris County case from the late 90s that suggested that perhaps it was, but wasn't really definitive. In this particular case, the appellate division agreed with the trial court that said, yes, that sick leave that you acquired under the 2012 agreement was compensation that you had earned, you 4 employees. And once you have that, it can't be taken away absent a knowing waiver. You can't retroactively negotiate that away. So in this particular case, what we've seen is these 4 employees were eligible for the higher payment for unused sick leave, not the lower payment under the most recent collective bargaining agreement. Now that has the potential to impact a lot of employees because many school district contracts have decreased the amount of reimbursement for unused sick time over the last few years. So I call that to your attention, and it certainly got my attention when I read that one. One of the biggest changes, one of the most important decisions in labor law and generally across the country, in New Jersey in particular, was the new U.S. Supreme Court decision in Janus versus AFSCME Council 31. This decision came down in June 28, 2018, and held that agency shop fees are unconstitutional in violation of First Amendment rights to free speech. This overturned a 1977 Supreme Court decision in Abood versus Detroit, which basically upheld those fees as a valid exercise of union's authority. Now, you may remember that in 2016, a similar case had come before the court, Friedrichs versus California Teachers Association, and unfortunately at that time period, Justice Scalia died, leaving 8 justices. There was a 4-4 vote, and that upheld the Ninth Circuit decision in favor of the California Teachers Association. Justice Gorsuch gets appointed to the court. We now have 9 justices. The matter is heard in 2018, and in a 5-4 vote, the court determined that agency shop fees were unconstitutional. So what does that really mean? Union employees cannot be compelled to join or pay fees to the union. If they are non-union union employees, they're still covered by the terms and conditions of the contract. They get the benefit of the collective bargaining agreement, and they must be represented in contractual grievances. Consent for deduction of union dues has to be clearly and affirmatively given, and you can't be an opt-out. It has to be an opt-in for new employees. This decision basically overturned 2 New Jersey laws that we've had agency shop in New Jersey since 1979. The 1979 law allowed unions to negotiate a representation fee in lieu of dues, could not exceed 85% of the fee. The idea being that if you're getting the benefit of the agreement and the benefit of representation, that's worth something, and that the 15%, 100 minus 85%, 15%, would be the amount of money that arguably you'd be used by the union to support their political causes, things of that nature with which a potential member may not agree. In 2002, with an amendment to the PERC law, it took agency shop to the next level, in that if it were not already in the agreement, the contract, the union could petition PERC to order agency shop. Now that provision basically had the effect of creating 100% agency shop in all public sector contracts, because PERC was going to order the agency shop if the local public employer disagreed. So it wound up being in there anyway. So it's basically 100%. As the Janus decision was approaching, Governor Murphy signed into law the Workplace Democracy Enhancement Act, and it basically gave majority union representatives access to a lot of additional access to members of the negotiations unit in the schools. So let's take a look at some of the aspects of the Workplace Democracy Enhancement Act. The majority representative, the exclusive representative union as it's described in the statute. Now, that's whoever is representing the employees. It's not any union, it's the ones representing those particular employees. They get to meet with individual employees on the premises during the workday. You can see to investigate and discuss grievances, workplace complaints, etc. They can conduct meetings on the premises during breaks and before and after the workday, so not interfering with class time, to discuss workplace issues, collective negotiations, etc. They get to meet new employees without charge to pay or leave time of the employee within 30 days of their hire, and they get to meet with them within 30 to 120 days, for 30 to 120 minutes of time. That's occurring during the normal workday. Notice the difference between number 3 and numbers 1 and number 2. A somewhat controversial provision allows the unions to receive from the employer the employee's home and work contact information within 10 days of hire. So email address, cell phone numbers, whatever the employer may have about the employees, the union gets to receive that. It's updated 120 days. It's not deemed a government record, so not everybody gets to see it. And the first time period for that information to be handed over was January 1 of 2019. And so just recently was the first round of information. 120 days after January 1 gets us to around April 1, so any updates would have come in April 1. The exclusive rep also gets to use the school district email system to communicate with members. That has raised some issues in terms of open public forum status. We'll talk about that a little bit later, but they get to use the email system to communicate. They get to use school district buildings and facilities to conduct meetings with their union members. Can't do partisan election matters, Republican, Democrat elections, support who you're going to support, who you're not. Can't do that on the school building, but can meet on there with other union members for other union reasons. School districts may not encourage employees to resign or relinquish their membership in a union or to revoke their authorization to reduce union dues. If they do so, that's deemed an unfair labor practice, and we'll see some information down the road about that. The WDEA also classifies all employees, including part-timers, which is significant, as part of the negotiations unit, unless they're confidential or managerial. Many collective bargaining agreements in their recognition clause do not include part-time employees. Part-time employees now by law must be included in the unit, and therefore their terms and conditions of employment become subject for negotiations as well. We've seen some what they call unit clarification petitions to decide who's in and who's out with PERC, addressing whether these certain part-timers would be in or not. And the other piece about if you wish to drop out of the union, you need to make that determination by written notice during the 10 days following the employee's anniversary date of employment. For most employees, that's September 1. Of course, they're mid-year hires, so you've got that period of time. So it basically creates a window of 10 days from September 1 to September 10 for anyone who wants to withdraw from the union. Previously, there were 2 different time periods, the beginning and the end of the year, where folks could choose to opt out. This was a change in the law, and it's been suggested in certain litigation, as we'll see, that goes beyond what Janice would suggest and would also be unconstitutional. So we'll see how that plays out. What's happened in Janice? The Department of Labor, the New Jersey Department of Labor, with the Department of Labor of New York State, issued joint guidance that essentially said, and you have a link right there to that essentially said, Janice only pertains to agency shop and nothing more, and nothing else has changed in labor law in New Jersey and New York. There was some early litigation before PERC where the 2 school districts, Telenco and Chatsworth, decided we don't have information about who's in the union and who's not. So we threw some of those records out, and we don't have that. We want everyone to re-register, just like we would sometimes re-register students for attendance purposes. PERC determined that that was a violation of the WDEA. It was an unfair labor practice because they viewed it as encouraging union members to drop out. So though there are 2 PERC decisions on that. Now, access to school email systems, the question is, we talked earlier, does this create a limited open public forum for purposes of freedom of speech rights? And what do I mean by that? Well, a lot of times you look on the school district website and there'll be all the email addresses for the teachers so that parents can access teachers and email them and engage in discussions with them. Now we have the union having access to this information. So there are these email discussions that are going on throughout the system. There's been a forum created for discussion. What has happened is that some anti-union people, different union people, have accessed the systems and suggested you shouldn't be in a union, or you should join our union, or putting information out there that would be different than what has traditionally been there. In certain school districts, the Board of Education has been asked by the local association to make those folks stop, to block them from access to the system. I'm not aware of any school districts that have blocked them because I think most folks understand that this is a limited open public forum. It has been a position in some of the litigation that we've seen. We talked about the unit clarification petitions in terms of the part-timers getting in there. There have been some of those filed with PERC. And one of the objections in some litigation we'll see coming forward is that this idea of the union having access to personal information of employees, like email addresses and cell phone numbers and items of that nature, invades the privacy interest of those individual employees. We've seen in many boards and many school districts a deterioration of the Board of Education union relationships. We've seen affirmative action complaints filed by members versus non-union members. We've seen an increase in grievances and litigation and some stronger discussions of collective negotiations. Not a surprising development in my mind. My sense is that if you have in the current situation, most unions are going to look to prove their value. And they're going to prove their value by showing that they're working hard for their membership. All of the matters that you see here play into that demonstrated value of being a union member and the fact that they fight for their people. I think that's why we've seen increased litigation. It's why we've seen some stronger stances at the bargaining table by local associations as they represent their employees. I think it's just part of the dynamic now that no longer 100% agency shop, so local associations and unions have to fight every day to keep their membership. So I think this increase is not, it is to be expected and probably will continue. As far as union membership issues, so far we have not seen a big change, not a big dropout of union members. And I think that comes from a couple of different reasons. One, people are creatures of habit. If they've always been in a union, they're always going to stay in a union. There's always some pressure brought to bear in the local associations to be a union member, that not be that outcast. Even what was there for agency shop folks back in the day, keeping people involved. I think showing the value of the union also plays into it. Some unions are looking at different representation issues, like for instance, for the non-members, if it's services that they need other than negotiations, grievances, perhaps setting up a schedule fee as to what those services may or may not cost. We're watching that develop as well. Current litigation, you'll see 3 cases listed here: Smith versus NJEA, which is out of Clearview Regional, Fischer versus Speck and Murphy out of Ocean Township, Thulin versus AFSCME, which was a Monmouth County case. They are all federal litigation matters that are contesting the Workplace Democracy Enhancement Act provisions of employee information, of the 10-day window, challenging those particular items, and those are moving through the courts, and we'll see where that plays out as to whether or not those items maintain or survive a constitutional challenge. I think the one that probably has the most traction that may see a change is that 10-day window. So we'll see what happens with all of that. Where I think this is all going to go, and this is a Mike Kelber opinion, this is not necessarily a Legal One or FEA, NJPSA opinion. Where I see this going down the road is it depends on individual situations where people feel aggrieved, feel they didn't get the representation they wanted, and then make determinations to sever their ties with the union and put their dollar amounts in their pocket. I'll give you one anecdotal situation of a contract settlement of which I'm aware, where there was a reduction in the contribution to healthcare of the Chapter 78 contributions, 85% in year 1 of the contract, 80% years 2 and 3. But with that came an increase in copays and an increase in deductibles. So for certain members of that association group, particularly parents of young children who had a lot of pediatrician visits, they looked at that particular change in their healthcare coverage and said, this is not good for me. it's actually going to cost me more with this change, even though I'm contributing less out of my paycheck. And so circumstances like that led to some of them to consider leaving the union, taking their $1,200 in union dues and using it to pay their increased copays and deductibles. So it's those kinds of circumstances that may lead to some of the changes coming forward. Where we'll be 5 years from now will probably depend on what kinds of settlements are, how well the union represents their membership, how people feel aggrieved. In states that do not have agency shop, generally that number has shaken out to be between a 60 to 70% membership rate. New Jersey is a very, very strong union state. So I doubt if we're going to get to that point in terms of those numbers, but I think you probably will see a reduction in union membership, unless, of course, some other issue comes up to push that even further. This marks the completion of Part 4, Collective Bargaining Rights. Please proceed to the Collective Bargaining Rights video, which will include commentary by Paul Kalak. Upon completion of the video, please proceed to Part 5, Employee Discipline and Criminal Charges Against Employees, which will include commentary by Sandra Jakes, Legal One Supervisor of Legal Research and Content Development. Thank you for participating in Part 4 Collective Bargaining Rights, and enjoy the rest of the course.